Namaskar. We are delighted to inform that as part of Symbiosis Golden Jubilee celebrations, Symbiosis Law School NOIDA, in association with Lex Witness, India's first magazine on legal and corporate affairs, has organized a webinar series titled Knowledge Series on Law and Advocacy. Leap 3 of the series is scheduled today on the topic Law and Practice of Law in Changing Times. We are delighted to inform you all that we have the gracious presence of Honorable Shri Ravindra Srivastava, Senior Advocate, Supreme Court of India, and former Advocate General of the state of Chhattisgarh. And I would like to put on record, he was the first Advocate General of the state of Chhattisgarh. Mr. Ravindra Srivastava, after being admitted to the membership of the District Bar Association Raigad, started his professional endeavor from the chambers of his father, late Shri D.P. Srivastava, an eminent advocate in the state, and worked on civil, criminal, and commercial sides in the district session and revenue courts. After working in the topmost law chamber of late Shri Y.S. Dharmadhikari, former Advocate General, Madhya Pradesh, from 1983 to 1985, he established his own practice and since then has been regularly appearing before High Courts and Supreme Court. He was designated as a senior advocate by the full court of the High Court of Madhya Pradesh in July 2000 and was the youngest to be so designated in the High Court. He was appointed as one of the youngest ever and first Advocate General of State of Chhattisgarh on its formation. Mr. Ravindra has appeared regularly for several important civil and constitutional litigation in Supreme Court and argued as senior counsel in the Supreme Court in constitutional benches 5 and 9 judges, such as presidential reference in 2G matter, coal allocation matter, constitutional amendment case relating to appointment of judges in High Court and Supreme Court, and 9 judges cases recently on the validity of the imposition of entry tax. He has appeared in the Supreme Court for the principal accused in high-profile criminal matter arising out of coal allocation dispute in which former Prime Minister was also accused. He has appeared as arguing counsel in the election case for late Srimati Sushma Swaraj, former Union Minister of External Affairs. At present, he is involved in the constitutional matter relating to the status and rights of the Parsi women after intermarriage, and also representing Dow Chemicals in curative petition Bhopal gas tragedy matter before Honorable Supreme Court's Constitution Bench. There is much to say about the dignitary who would be addressing all of us today. Without much ado, I hand over the baton to Ms. Mayuri Raghuvanshi, who is the moderator for the today's session, to take it forward and explain the rules of the housekeeping to the participating audience. Over to you, Ms. Mayuri.
Thank you, sir. Before I request sir to start the session, I would like to state the housekeeping rules before all the attendees. There is a Q&A box. If you do have a question during the session, I request you to kindly place your question in the box, and I will place them before sir as and when he permits. Also, towards the end of the session, we will allow the attendees to go live with their questions, for which I request the attendees to press the raise hand icon button, which they can see on their screen. With this, I request sir to kindly begin the session and enlighten us on such a contemporary and relevant topic. Thank you, sir.
Namaskar. A very good afternoon. Thank you, Dr. Ravindra, for a very generous introduction by you. I wish I deserved even a bit of it. But I do respect your views about me, and I say I'm indeed grateful to you. I must compliment you, your faculty, all your colleagues for organizing this very useful knowledge series on law and advocacy. And I'm very certain this is of immense help to the students, to the members of the profession, law fraternity, and the society in general. I must compliment you wholeheartedly for this. So, my most dear young student friends, Dr. Ravindra, the director of the campus, my very dear colleague and my sister, Mrs. Mayuri Raghuvanshi, who is responsible for bringing it here in front of, Dr. Meenakshi Kaul, Mr. Akshay Alag of the Lex Witness, learned members of the faculty, and ladies and gentlemen. I must thank you for giving me this opportunity of being together with you this afternoon. And it gives me pleasure unspeakable to be particularly with the young friends of the campus. It is such a rare opportunity and privilege for me, and such opportunity comes very rarely in lifetime, that one gets to engage directly with brilliant class of the most fertile and young minds who are studying in the campus and even outside the campus. I have a definite conviction that my young friends are the storehouse of knowledge and information, wisdom least lacking. You are the reservoir of energy, and I feel that when I connect myself with you, that is a source of energy. I get charged. I get replenished of all the energy I have spent over the years in my life and in my profession. And therefore, I must thank you. I must thank you very much. Let me also offer my heartiest felicitations to the students for having chosen to join the course of study of law and being the student of this campus of Symbiosis Law Institute, which is a deemed university, one of the finest educational institution, the premier institution in the country, which is imparting education not only in law, but in many, many other subjects. The combination of the talent and teacher of this campus, I'm sure, is bound to produce some brilliant stuff, very useful entrants in the law profession and asset to the society. So my congratulations. However curious I may be, I do hesitate to ask my dear students a questions to you. And I have a question. Why have you chosen to join law as a course of study? I'm sure you may have your own answers, and you may have very different answers. Each one of you must have been prompted or guided by some object of your life, of your aims and your goals in the life. But I must say that your choice of choosing law as the study is a very commendable choice and greatly worthy of respect. I do feel that with your talent and ability, you could have very successfully opted for any other course of study, such as in medicine or engineering or technology, humanities or commerce, management, and so on. And undoubtedly, each one of them are extremely important and needful to the society. Each study has its own value, relevance, and utility. But let me tell you, my dear students, that being a student of law, and which eventually will take you to be a part of the legal fraternity, there is a very distinct edge and advantage over others. I'm not trying to undermine the importance of any other profession like medicine or engineering or even of a teacher. They are so valuable. Each one of them are engaged in the service of the mankind in their own way. But law is one such profession, I wish to tell you, which gives you enormous scope and opportunity to instantly and directly connect with the society. And when I say society, I mean from the poor on the field, from the vendors on the street to the richest echelon of the society, the most affluent, from the middle class to the overprivileged and also the underdogs, billionaires to the downtrodden, the strong to weak, or the weakest, rich and poor, powerful and helpless. You know, each one of these classes have their own problems. No person, however rich, powerful, influential he may be, resourceful he may be, is free from problem in the living and in the society. Each one of them, therefore, my dear students, would need you to solve their problems. Problems of different kinds. And please don't mind saying me, and the others must excuse me for this. Next to the doctors, it's law practitioners who step in the sufferings and miseries of the people. When people are in distress, physical or emotional, mental or health, medical distress, they need either doctor, need lawyers, and the law practitioners. So as a member of this great fraternity, you will fight and secure to the people justice, and justice which is the ultimate dignity of the man and women. You, the students, when you become part of the legal fraternity, will become instrument of the process to do away injustice, deprivation, exploitation, tyranny of the power, and secure to the common people freedom of rights and privileges of being citizens of this country. You will have natural access to the various facets of governance and insight to the problems of the government, the problems of the citizens and subjects, the failings and achievements, the roadblocks and the opportunities. And this profession will permit you plethora of such opportunities to lead the society. And this is an advantage which the law profession gives to you. I may not be wrong if I say that that is how you find the leaders of the society, the leaders of the country, in the field of public affairs and politics, in the parliament and the members of the legislative assembly, mostly either coming from the law profession or having some connection with the law profession. As members of this profession, you will fight against injustice and deprivation of rights. It will be your opportunity to develop a social order where there will be peace, prosperity, and dignity. It will be your task to ensure that there is clean air to breathe, pure water to drink, healthy and safe environment, secured and free movement of the people, fair and equitable distribution of natural resources, and there will be social harmony. There will be equality of status and opportunity, and all men and women are happy. You will be responsible for achievement of these goals and make this as a beautiful society on the earth to live on. You will see that the poor are not made to suffer for basic needs of life. They live in hunger or die in poverty. I therefore salute each one of you to have joined the course of law, and thereby I believe you have committed yourself to the services of the great public cause. I have tremendous hope from you. You are the future of this society, this great country. You are the solution maker of all the problems that we face in various fields of our life. Now, I'm going to talk a little about the subject of today's webinar, that is law and practice of law in changing times. I have deliberately and after a great deal of thought and discussion with my friend, Mrs. Bayuri Raghuvanshi, chosen this topic. It is close to my heart. I felt the need to talk about it in the current circumstances. I know the width and the amplitude of this subject is very wide, and I'm not that competent person to touch all the aspects and nuances of the subject, much less in such a time it is available at our disposal. But I wish to highlight some issues which you may find worth thinking about, pondering about. And I must tell you, when I'm doing it, I'm neither an expert nor a scholar. I'm a man of very ordinary means, notwithstanding very generous introduction given by Dr. Sahab. I'm neither a teacher nor a philosopher. However, as a member of the law profession, I have had my own experiences at different levels over past 40 years. By grace of God, I have held some capacities in the establishment, which gave me immense exposure and experience about the government functioning, about the problems of the citizens, the constraints of resources, the opportunities and the lost opportunities. And I have had the advantage of practicing at the lowest ladder of the hierarchy of the courts to the highest. When I joined my father's chambers, he made to go to the Tahsildar's court for cases of mutation, for royalty cases, for small cases, because each one of them give you some exposure. So today I wish to speak you as a member of the society. We all live in and share common assets. We share common privileges, you and me both. We share common rights, and we ought to share common duties as well. And at the same time, we have our own common problems. I may sound at some level of my speaking that I'm a very worried citizen. But yes, of course, I am. I have children and grandchildren. I'm worried for the present, and also am I worried for the future. I may sound cynical, but never mind. So the friends, when I have to speak about the law as one limb of my subject, and then I will come to the practice of law, which is the practical aspect of the subject. All of you know what the law is. Yet let me tell you very briefly, a classic definition of law is a code of conduct, a rule, which is laid down or ordained or established by an authority which must be respected and is competent. And that rule or that code of conduct, which has been laid down having the force of law, governs the existence and coexistence of the fellow members of the society. That is the order which must be obeyed and followed by all citizens and which is subject to legal consequences. Everyone takes an oath to abide by law and thereby subject itself to a pledge to constitute an orderly society where there is peace, there is prosperity and happiness. I'm not dealing with, this is a meaning which I have narrated before you in my own understanding. In my own humble understanding, I have not narrated to you a jurisprudence or a classic text from any authority or author. It is simply a code of conduct, and that is what the law is. Can I also tell you, in my own way, what is the essence of a study of law? A study of law, in my understanding, is a study which helps you become an ideal and responsible citizen. A citizen who would know the norms of the conduct to make it a good society. A citizen who would be awakened citizen and will spread peace and harmony, and at the same time will rise against the state atrocities of power. The study of law is to become a citizen who would ensure dignity to self, the fellow brothers and sisters, a citizen who will fight against the violations of civil liberties and fundamental rights, a citizen who will nourish, sustain, and give meaning to the democracy and democratic rights. A study of law will help and should help to become a citizen who will cherish, uphold, and enforce the Constitution. It should produce citizens who will establish equality, who will observe dignity, ensure dignity, peace and prosperity in the society and in the world order. This, in my understanding, is the essence of the study of law. And after completion of the study of law, if you become a lawyer, if you choose to become a lawyer, you have many choices. I know these days the first choice is not to become a lawyer because there are other avenues open and each one of them are equally important. But a lawyer, being a lawyer, has its own privileges and duties. And I wish to tell you, and you have an example, Mayuriji is in front of you, that when you choose to become a lawyer by grace of God, and I wish for all of you that you will float in money, name and fame, respect and dignity, which is unparalleled. But at the same time will lie on you enormous responsibility of being an instrument of fight against injustice. And you may, by your choice, become a judge also. As a judge, the most respected, coveted class in the society, you will perform a role and discharge a responsibility as the ultimate protector of the rights, as the administrator of justice, and which brings you respect only second to the divinity, that is God. But being a judge requires a lot of sacrifice, utmost sacrifice from you in your personal life, your professional life, your personal life, your family life, and your social life too. It would require the highest standards of probity and integrity, moral values. And if you choose to become a law teacher, you will educate the masses, you will educate, you will produce citizens. You will be performing the most sacred duty, and the role of the teacher is one of the reformer. As teacher, you will be sowing the seeds of all virtues and values in a citizen in making, a lawyer and a leader of the society. Law as it is, and it is required to be under our constitution, I wish to briefly speak about it. You all are students of law and therefore have studied the constitution. I'm sure you will study the constitution in greater details. And when you join the practice or you join the services, judicial services, you will deal with the constitution in even finer and detailed aspects. But in our republic, we have adopted a constitution which is about governance according to the rule of law, as distinguished from the rule of man. And when I say rule of law, it means it is ordained to have a society governed by certain established rules, code of conduct, legal principles, and not simply dictates of discretion or whims and caprices of some individuals who may enjoy the authority or the seat of the power. The source of the law is the Supreme Constitution. And it is an interesting coincidence that only 2 days ago, we have celebrated the Constitution Day and taken our pledge to abide, to respect the Constitution. When we talk about the lawmaking, under the Constitution, the powers are given to the legislature, which is either the parliament or the state legislature. And there are diverse fields of legislation as enumerated in the Constitution. But what is the key to lawmaking? And please remember, the key to lawmaking is the preamble of the Constitution, which sets out the goal to be fulfilled by an integrated and continuous process. That is the charter of the Constitution. No authority under the Constitution has untrammeled powers. The width and amplitude or the longitude of the powers are all defined. The fields are separated and demarcated. And every single individual or authority under our Constitution is bound by the constitutional discipline. There are fundamental rights. There are directive principles. And there are fundamental duties of the citizens. All have to work in peaceful harmony in a cohesive manner to create a social order which will guarantee to the citizens liberty and equality in life, bring about prosperity in living and dignity in existence. We have had the experience of the working of the Constitution since 1950. We have had the experience of the making of the law by respective legislatures. Hundreds and thousands of legislations have been enacted, ordinances issued, amendments have been made, and repeals have taken place. But the question that I wish to pose, and that is the core of my discussion today, is, has the march of law been keeping pace with time? Has it been responsive to the contemporary needs of the society, the citizens, the common people of this country? You may have different views. I have my own views. But there is a room for thinking and argument that even though there has been enormous progress in the lawmaking, the legislations have not been lacking, but there is some gap. At times, speaking for myself, I feel that the law has been little static. It has not walked along with the society, step by step, as it ought to be. So therefore, I feel that change is the need of the day. It is the order of the day. Evolution is a law of the nature. Change is inevitable and unavoidable. Lawmaking and law practice cannot remain an exception from the nature of law of change. It has to evolve. If the nature and climate are changing, flow of river and color of the sky are changing, land and forests are changing, demography is changing, nature and behavior of men, women, and children are changing, society is changing, state is changing, globe is changing, universe is changing, values and ethos are changing, life and living patterns are changing, technological changes are happening. My dear friends, can the law or the lawmaking or the law practice remain static? My answer to this question is no. Certainly it cannot. And I recently came across an interesting speech by a famous judge, Judge Judith Kay, the Chief Judge of the New York State, who delivered a speech in 1997, recognized and emphasized the need of change. And that speech is reported in Hastings Law Journal. I found it extremely interesting, extremely insightful. And I'm very tempted to quote a few passages from that speech. And I quote, says in Justice Tobner's view, the law is doomed if it remains static, unresponsive to current needs and concerns. It takes vigorous advocacy by those who perceive the need for change and are willing to challenges established by rules. In an article which he quotes 25 years ago, written by another judge, Justice Tobner, he says that indignantly rejected the suggestion that young lawyers should not expect to bring about improvement in society through the practice of law and go to politics. In the words of the judge, law as an instrument of social control must by necessity respond to the emerging pressures for change within our society. And if the legal system is to remain viable in the face of today's rapidly shifting modes, we acutely need the advocates of change. He says, as a consummate common judge, Justice Trobner understandably focused his article on the need for the substantive law to keep pace with the changes in society. I want to echo but also enlarge his challenge to young lawyers. If the legal system is to remain viable in the face of today's rapidly shifting modes, we acutely need advocates of change not just in the substantive law, but also in the operation and administration of courts. The change in postmodern society are in every direction: advances in technology, declines in community institutions, shift in values. Law school curriculum are full of exciting new theories, doctrines, courses, and programs that push the frontiers of law. But you don't see much about whether day-to-day court operations and administration of structures should also change, and if so, how. A legal system remains viable only if it responds to the present-day needs and concerns of the public. If we expect our legal system to remain vital and strong into the next century, we need advocates of change to think seriously, not only about the exquisite nuances of law, but also about the hard reality of how our courts are functioning. Therefore, this law of change, which goes along with the law of the nature itself, in the field of the law is extremely beautifully described by the judge, which from the passage which I quoted just now. Not that we have not felt the need of the change, we have also. And we have also felt the need of change or the review of the functioning of the Constitution, the basic document, the supreme document. The Constitution, which is a living document and must march progress with the times and needs. Friends, you are aware that there has been a long talk about the review of the Constitution itself. In election manifesto of various parties for last almost 4 decades, there has been a clamor for a review of the Constitution. Why? Because of the evolution that is taking place, the changes which are taking place, vast changes which are taking place in the diverse fields of our life in the society. And I wish to tell you, it's a matter in every one of you's knowledge, that ultimately the government of the day in the year 2000 set up a very high-powered commission. And my dear friend Mayuri will know more about it, in detail about it. That commission came to be known as Justice Venkatachalaya's commission. Justice Venkatachalaya, one of the most respected judges of the Supreme Court, who have retired, who by his conduct, by his learning, by his sense of justice and delivery of judgments, has added immense glory to the institution of the Supreme Court of our country. He headed the commission. The most eminent jurists and the legal minds who were available in the year 2000 were made part of the commission. They were former judges of the Supreme Court. They were former attorney generals, present attorney generals, very distinguished jurists, public servants, former ambassadors, so that this commission could be a very wide base with a very wide spectrum of searching and thinking. This commission produced a report in the year 2002, after about 2 years of extensive and elaborate discussions and interaction with the stakeholders. It consulted so many people from across the segments in the society, not only the lawmakers, the jurists, the lawyers, the judges. It consulted the bureaucrats, the businessmen, the literary persons, the men of the literature, the various organizations of the forums of the citizens, laborers, industrial workers, employees. Such an extensive, one of the wonderful documents that it produced in the year 2002. The recommendations were submitted to the government in March 2002. The recommendations in the form of report run into 2 volumes, and chapter 11 of that recommendation contains recommendation about the changes which the commission studied and found it necessary to be made, or at least to be considered for being made in the Constitution by the appropriate authorities. I wish to take some time of yours because the change was felt in the Constitution itself, and this was not a political constitution. It had no political leanings. It was most independent and impartial, without any political ideology. They only thought about the country. They only thought about the people of this country. They thought about the welfare of the people of the country. They thought how best the tears in the eyes of the common man can be wiped out. And if I tell you today, some of the recommendations, they made recommendations for changes in the fundamental rights, in the directive principles, in the fundamental duties, in regard to the electoral reforms, the union and the state relationship, judiciary, financing, and so on. But today, only for the sake of paucity of time, I will tell you, and then you will realize how pertinent and relevant those recommendations were. What extraordinary vision those people had in the year 2000. And when we see them in today's perspective, we realize that they were full of values. Now they recommended change in Article 15 and 16 of the Constitution, which were aware are the articles guaranteeing equality. They say that in Article 15 and 16, prohibition against discrimination should be extended to ethnic or social origin, political or other opinion, property, or birth. So none of them should be a cause of discrimination or classification. See what's happening today in today's context. If this had been followed, and I'm not saying the government after the government have not looked into the reports, while suggesting changes in the Article 19(1), look what they said in regard to the freedom of speech. And when you see that, and when you consider that in the light of the happenings of the recent past, you will be amazed. They said in Article 19(1), all citizens shall have the right to freedom of speech and expression, which shall include the freedom of the press and other media, the freedom to hold opinions, to seek, receive, and impart information and ideas. Then they suggested some change in Article 21. I'm only highlighting those which are very striking changes recommended by that commission. They recommended change in Article 21, and Article 21, as you all know, is in regard to the freedom of personal liberty. They said sub-article 2 should be inserted after Article 19(1), says that Article 19(1) says that no citizen shall be deprived of liberty without authority of law. Then sub-article 2, which they recommended for insertion, was no one shall be subjected to torture or cruel, inhuman, or degrading treatment or punishment as part of the fundamental right of citizen. Consider what is happening around us. They said in another sub-article they recommended for insertion in Article 21, and how wonderful it is. Please consider this. Sub-article 3 proposed by them is, every person who has been illegally deprived of right to life or liberty shall have an enforceable right to compensation. That means if there is an infringement of right of liberty, for such infringement, there shall be a fundamental right to seek compensation. If this recommendation is accepted and is incorporated in the Constitution, and imagine that becomes a part of the fundamental right of the citizen, the violations of fundamental right, which are taking in such a reckless manner these days, would have been greatly prevented, because this law fixes a responsibility. The violator of the law will not go free, or if there is a deprivation, the citizen for the violation will have to be compensated. Then they recommended a new article, namely 21A in the Constitution, to be added. And that article reads, 21A, every person shall have the right to leave the territory of India, and every citizen shall have the right to return to India. The right of free movement. I'm sure I don't have to elaborate, and you will find the relevance of all these suggestions and the recommendations made in 2000, some 20 years ago in the present context. Then they suggested insertion of a right, and if these articles were incorporated, I don't suggest that fully or even if partially, 21B, which was suggested by the Commission, was to this effect, that every person has a right to respect for his private and family life, his home and his correspondence. How private life is being discussed these days in media and in public domain, without any check and balance, without any sense of respect, and without any sense of sensitivity. This article takes care about this. Then likewise, so far as the detentions are concerned, they wanted an article, a provision to be added in the Constitution which says that when detentions can be authorized, they're legally permissible, what we call preventive detentions. They say that provided further that nothing in this clause shall authorize the detention of any person beyond a maximum period of 6 months as may be prescribed by law made by the Parliament under clause so and so, so and so. They wanted a specific article. We have Article 32, which is the approach to the Supreme Court for enforcement of fundamental rights. But this commission realized, and in 2050 and 2050, after 50 years of experience of working of the Constitution and the functioning of the Supreme Court, that Article 32 was not enough. So they wanted Article 30A capital to be added in the Constitution, and that was in regard to access to courts and tribunals and speedy justice. Look here, access to justice. Tribunals and speedy justice, they thought, must be a part of the fundamental right under the Constitution. The provision that they suggested read like this: everyone has a right to have any dispute that can be resolved by the application of law, decided in a fair public hearing before an independent court, or where appropriate, another independent and impartial tribunal or forum. Sub-Article 2, the right to access to court shall be deemed to include the right to reasonably speedy and effective justice in all matters before the courts, tribunals, or other fora, and the state shall take reasonable steps to achieve the said object. Then likewise, there are many, many other articles which are most interestingly, and look at their vision. You know that we have a chapter 4 in the Constitution, which is about the directive principles of state policy. And you also know that the directive principles are not enforceable in court of law. So they remain sometime dead letters in the Constitution. Many of the provisions of the directive articles have remained totally unattended. These are all the ordains or the directions of the constitutions which the state as part of the constitutional duty must carry out. So they suggested an amendment in part 4 of the Constitution to read as directive principles of state policy and action. So therefore, all these ideals or goals which are set out in the chapter of directive principles, in order that they're performed as part of the duty, are also followed by action. And that's a requirement of the Constitution. In order that it becomes enforceable, some authority, the people will see that the action is taken on the various directives which are available under the Constitution as directive principles. And no more an argument would be open to the state machinery that directive principles are not enforceable in court of law. The Commission made recommendations about clean water and air, control of population, and so on. You will be really pleasantly surprised to know that the Commission regarded that the right to clean water, the right to clean air, unpolluted atmosphere will all be part of fundamental right. And look at the struggle that we are going through today for drinking clean water, for having clean air to breathe, and live in an environment which is clean and safe. They made very meaningful recommendations for the electoral reforms, which goes to the basics of the functioning of the democracy. For the judicial reforms, for setting up an independent commission which will fund the infrastructure, judicial infrastructure, its building up, its updation. It's not possible for me to deal with all those recommendations. All of them are so wholesome and salutary. But it is rather sad for me to say that government after government have not looked into these recommendations. So much of dust has gathered over a period of time, almost 20 years now, on the volumes of these reports, that this report has almost been pushed to the archives. And thereby, a great loss has been done to us. I exhort the students community to please study these recommendations. They will make you awaken, they will enlighten you that what are the areas which require changes. And those changes have to start with the changes in the Constitution itself. I'm not suggesting that the basics of the Constitution should be changed, but there is always some scope for ironing out the creases in the working of the Constitution, because it has to be progressive, it has to be dynamic, it has to be a living Constitution, which must correspond to the basic needs of the times of the people. Law by legislatures, it is often said that there is a presumption that lawmakers know all about the lawmaking. It's a very high-sounding presumption, but I wish the presumption is rebuttable like any other presumption in law. But yes, they are all men of wisdom. They are men of experience. They do understand the needs of the problem of the subject. And therefore, when legislation are passed by them, they are attributed with the great virtue of legislative wisdom, protecting the legislation, which is called legislative policy. And that is why a presumption of constitutionality attaches to a law made by the competent legislature. But my friends sometimes think, is this presumption a reality, or a mere myth, or an overblown hypothesis? I therefore think that we require change. We require changes in the whole structure of law and the lawmaking process itself. I'm aware that our legislatures have done tremendous job ever since the freedom, ever since the Constitution has come into force. There have been eras of lawmaking of reforms, for achieving social justice, for ensuring equality, for undoing economic disparity, and various other things. But sometimes we should also ponder that in the recent past, when the legislations have been passed, please make it a subject of a study the last 20 years of lawmaking by the parliament and even the respective legislatures of the state. How many of the legislations are really progressive legislation, social welfare legislation, legislation which are really needed for social justice, economic justice, for political justice, for alleviating the cause of the poor, for removal of poverty, and so on. This can be a matter of study. At the same time, the judges, the courts of this country have also done enormously while performing their judicial functions. There has been a tremendous lawmaking by the judgments of the court, where they try to expand the meanings of the rights and duties and privileges under the Constitution by giving expansive interpretation, adding new meaning and dimensions to it. The concept of equality, the concept of liberty, the concept of state accountability having been defined in a progressive manner. The jurisprudence of public interest litigation, the sensitivity shown by the courts towards the problems of livelihood, the problems of environment, and other public causes are enormous. Their contribution is historical. And more particularly, I would like to mention the job that is done by the subordinate judiciary, the arduous job in such difficult circumstances, painful circumstances, in most agonizing working conditions. They work, and they work tirelessly, and they remain unacknowledged. That is the saddest part of the entire functioning of the judicial system in our country. The role of the subordinate judiciary is the basic, goes to the core of the functioning of the judicial system of the country. So there has been lawmaking both by the legislature and also by the courts, but it is my individual opinion, you may not agree with it, that it has not been in accordance with the pace with which the society is moving. There has been some element or some feeling of complacency or inertia. I wish that was not there. And that is what we wish to address today while we are in the lawmaking. Now, I should come to the practice of law. And when I say practice of law, I wish to tell you that our practice of law in courts traditionally or conventionally has been immensely and unduly tradition bound. While it is necessary to have established some traditions, follow them, the traditions lead to a system which is disciplined, which is respectful, but we also need to go towards innovations. The dimensions of the law practice are also changing, and have to be progressive. When there are various avenues open for the law practice, I think the practice as a legal practitioner is most important. Judges job is equally important, and so is the teacher in law. As practitioner of law, you may be doing immense service to the society. As I said in my initial discussion, because of your connect with the society, because of the access that opens up for you to get connected with the society. I'm tempted to give you a very basic example, not that it is an absolute truth or a universal truth. The doctors or medical practitioners are such an important part of the society. But how many times you come across an example where a doctor or a medical practitioner or a surgeon who is performing surgery is also actively involved in public affairs and the politics? And so also the engineer. The bureaucrats, yes, sometimes we find them. Doctor also, yes, are they devote their services to the public cause or the public affairs. Our union health minister is a medical practitioner. In contrast, look at the leaders who have been drawn from the legal profession and they are leading. So when the practice of law gives you an opportunity of being the advocate, an instrument of change, be it social, be it political, health and environment, deal with problem of land and resources, problem of livelihood and poverty, or a problem of law and order or crimes, or an issue of social and psychological behavior, is a problem of disparity to equality, problem of consumerism to consumer protection, labor to labor welfare, medical practice to medical negligence, public works to public corruption, trade and commerce and taxes, media debates to media freedom to media trial, and likewise any number of activities you can think of, you will find yourself associated with in some degree or form at some stage or at some level. Your exposure and your interaction with the community and community to the society, from the society to the state to the nation, and from nation to the globe, will be much and much closer and integral than anything else. So when I emphasize this part of your role as a practitioner of law, I do think that a new approach is a must. And that approach must be in tune with the changing times and the changing needs of the society. Not only that, you have to move from tradition to innovations, see huge opportunities in the most serious challenges and the moments of crisis, and deal with those issues with creation of a sensitized bar and bench, ensure access to justice, fair, speedy, and delivery, basic and non-derogable features of the constitutions, and that delivery of justice must be with accountability. Accountability of all the parts of the system of judicial administration will only improve the system. They will neither make it weak or weaker. Basic fundamental rights and human rights must prevail at every cost. Right to health and environment, basic and fundamental rights must yield to every other considerations. Alleviation of poverty, raising of level of nutrition, ensuring a dignified life must be the basic duty of the state, and you must be an advocate for the enforcement of those obligations of the state. Right to minimum health and care and education must be ensured as basic right. Social and economic justice must be paramount. Equality of opportunity of employment includes creation of avenues of employment. And when I have just spoken about the equality of opportunity in employment, I'm reminded, and I wish I had read that part of the Justice Venkatachalaya's commission, where the commission recommended that the right to employment will be a basic fundamental right. It would be an enforceable right. So I also think that the exploitation and distribution of natural resources, whether it is forest, whether it is minerals, or it is water, must be just, fair, and sustainable. And unsafe children or women means defaced nation. That must be prevented. There must be care and compassion for weak, unequal, and deprived. And there must be a paradigm shift in the very approach, angle, and perspective of the law practice. For you are the tools of change. While all this is correct, it is equally important that we need to build up the infrastructure, which is basic requirement. There is a huge deficiency in the infrastructure of the judicial administration at all levels. Be it the subordinate courts, the conditions are horrible. Be it the High Court, the lack of resources affect the functioning of the High Courts, or even to some extent the Supreme Court. The infrastructure upgradation is a task which must get its precedence, and the lack of financial resources must not come in the way. The requirements of separation of power, and I make a strong point for this, do require that an independent commission is set up, which may be known as a judicial council, which will examine the needs of resources, the final resources, the augmentation of resources, the upgradation of the infrastructure, and make provisions for its funding, so that the dependence upon the executive of the judiciary for seeking financial resources is minimum or almost nil. Then only it is possible to upgrade the infrastructures. The encouragement of the ADR system, alternative dispute resolution system, mediation and conciliation, lok adalats are all the necessary requirements of the change which the society is looking for. There has to be a prevent litigation, and we must follow a non-litigation policy. More than us, the government, which has at some point of time framed a litigation policy to minimize and curtail litigation in courts, must be made to strictly adhere to the norms and the procedure by which the litigations or the burden of litigation in the courts would be reduced. Appointment of judges must be strictly on merit. It must be by an honest process. The process must be independent, and the judges which are appointed are absolutely men of integrity and independence. The practice has to be technology based. The use of the technology has to be a maximum. There is no choice, there's not to. The technology is indispensable. Particularly in the COVID times, when we have seen the worst human tragedy, I also believe that it opens up huge opportunity for use of the technology and also the upgradation of technology. Whatever is happening today and the access of justice is possible is only because of the technology. Although I do remember that the Honorable Chief Justice of India, while speaking on the occasion of the Law Day 2 days ago, did say that lack of technology or no technology means no access to justice. He was obviously referring to those underprivileged class to whom the facility of technology is not available, either by means of their financial considerations or non-availability of the facility or the training or the familiarity with the use of the technology. So adaptations, necessary modulation, behavioral changes are necessary. We have to develop an attitude to break the barriers of taboos and go towards the use of the technology. I therefore recommend to you that all of you individually and together be an instrument of change, of law, and ultimately of the society, and eventually of the nation. Be a successful law practitioner and also be a responsible citizen. I wish to tell you that be ambitious, because with ambition comes the determination. With it comes the passion. Be ethical and shun temptations. No system of justice will work successfully, and particularly to wipe out the tears in the eyes of the weak and poor and oppressed class, without most predominant element of compassion. So anything you do must be with compassion. A justice delivery system without compassion is anathema, according to me. Love man, women, your nature, your environment, your surroundings. Love human beings. Love animal kingdom also. They are part of the same universe. And when I say love each other, I wish to tell you, love the God and fear the God. Fear that there is an authority who exists and who governs the rule, and be feared to him. Be respectful to your elders, be grateful to your parents, and be grateful to your teachers. I wish you all the best, very best in your future. I know the times are difficult. We are passing through great challenges, the worst tragedy of the humankind. But I'm equally sure that with your strength, your power, your will and determination, we will see through these difficult times, and you will remain the source of light, the source of strength to the society, and the society will be benefited from you. I wish you all the best to you. Thank you very much.
Sir, if I have your permission,
Yes.
place some questions before you that have come from the attendees. Sir, if I have your permission, may I place some questions before you that have come from?
Madam, yes, of course.
Akshayji, is there any question, any raised hand icon that you would like to take first?
Just a second, ma'am. Mr. Madhukar Sharma, please unmute yourself and ask a question live.
Yes. Good morning, sir. Am I audible?
Yes, yes.
Yes. So my question is that in the contemporary fact and circumstances, can the legal services be brought under the Essential Services Maintenance Act?
I think that your question is prompted by the situations of frequent abstentions from work.
Yes, sir.
That is seen, I mean, in the time. There are already judgments of the court. The Supreme Court has declared that a strike or abstentions by the lawyers is not legal and must be visited with serious consequences, penal consequences. So there is already a law which exists and that's enforceable by the bar councils and the bar associations that are there. If those judgments are followed in letter and spirit, and we become sensitive to that, and it lies upon every organ of the courts, the bar councils, the bar associations, and the individual practitioners. It may not be, to begin with, that itself will produce good results. And it may not be necessary because bringing them under the essential services and maintenance will have to create a legal regime which must be enforceable. Now, no study has taken place as to how that would be made possible. Now, it is not that this cannot happen. Ensuring essential services by the lawyers or by the members of the law practitioners is possible. I'm not mentioning a particular example deliberately, but it so happened when the lawyers of a particular high court went on a strike for a unduly long period of time, a very proactive step was taken to re-recognize the association, the High Court's Bar Association, and were denied of the privileges or the facilities which were given to them. So it is basically a matter of will to enforce the law that already exists in the form of the judgment of the Supreme Court and also the High Courts.
Thank you, sir.
There is a question about AI, use of AI.
Yes. So there is this question from Madam Meera Matthew. And
we have another live question.
oh, I'm sorry.
Please permit me to take that. Mr. Sorish, please go ahead and ask a question live. Mr. Sorish, can you please ask a question live? No response from your side, sir. We're disabling you right now. Mr. Soumik Ghoshal, please ask a question live.
Yeah. Good afternoon, sir.
Good afternoon.
Thanks for taking us back in time. It was almost like traveling in a time capsule to 2000, early 2000s, and getting to know about all the work that has been done in constitutional law by these great committees. While the suggestions that the committee that you spoke of were very, very important, and I believe they are relevant even to this date. I want to know your opinion. Do you think that because of the change in the nature of media and the way information technology has grown by leaps and bounds in the last 20 years, do you think that the provisions of our constitutional law particularly relating to freedom of speech and the limitations which are laid down in those provisions itself, are they adept enough to tackle these new challenges, or there is a relook required, or there is a need for revisiting the restrictions in a fresh manner, looking at the changes of the technology involved? And I'm asking this primarily keeping in mind the subordinate judiciary, because if a matter reaches the highest courts, which have the power to lay down the law, then there is no difficulty. But often what happens, the subordinate judiciary may not have enough indication of how to interpret the restrictions or what are the limitations on freedom of speech. So I wanted to know your opinion. Do you think that the present provisions are enough, or there is a relook required?
So far as the present provisions are concerned, both in the Constitution and in the IT Act, it is there enough. They're enough for the purposes of addressing the problem. You see, the problem really in this country is, and this aspect is not an exception to this, is one of implementation. One is a strong, robust will to implement and create a machinery for enforcement. We have the machinery of enforcement under the IT Act itself. But if there is a problem which is adding to the problem of improper or inappropriate use of the media freedom, it is a lack of the operation of that machinery and the enforcement provisions. Going back to the Constitution, the freedom of expression, the speech and expression is not an absolute freedom. The freedom is subject to limitations which are provided under the Constitution itself. So even if the existing structure of law is made operational in a very sensitized manner, responsible manner, I think the provisions are not lacking in their teeth to stop it. Number one, that is about the law. But the success of any law depends. We may go on making laws, we may go on adding laws, we may go on making more and more legislations in a knee-jerk manner. But the solution does not lie there. The efficacy of law always depends upon the acceptability of law by the people, the education and awareness about the need to follow the law. I think that is an area which requires emphasis. All of us, we realize that any improper use of the freedom at any level, whether I'm not particularly addressing on the media misuse or the media, but any level of the freedom, is definitely endangering the society, is harmful and detrimental to the society. So we need to have, if at all, a law which will create awareness, a compulsory education and awareness about realizing the values of the fundamental rights and the corresponding duties, because no right goes without duty. If there is a right, there is a corresponding duty also. And that duty must be strictly enforced. There must be a strict enforcement of law without any fear or favor.
Thank you, Mr. Srivastava. Mr. Arjun Chaudhary, please unmute yourself and ask the question live.
Well, thank you for the opportunity, panel, for giving me the opportunity to speak to Mr. Ravindra Srivastava, Senior Advocate. It's been a pleasure hearing you, sir. My question is related to the treatment of the law, not vis-a-vis when you're taking action against the state, but the treatment of law when it comes to the public or between members of the public. Do you believe the law and practice of law in changing times is now more just and fair, or is it more unjust and unfair?
No, I won't say that the practice law is unjust and fair. Of course, there is scope for its improvement. There is a need for its modulation or changes and its upgradation. But it's not unjust unfair. The enforcement or the administration of justice by all the agencies which are involved in the process is by and large done with the best of the intention and with the best of the ability and to the utmost of the capacity. The procedure, barring a few aberrations if you have in your mind, maybe, but administration is just unfair. Although, because of the limitations which are faced in terms of the huge load on the judiciary, the shortage of the infrastructure, the shortage in the number of judges, sometimes one may develop a perception that the treatment of law or the system of judiciary is not very fair to the people in common. Yes, that may be true. And that is why, rather than calling it unfair, I would say that there is a need, and a very strong need, I mean, there is no dispute about it, to make drastic changes and make improvements in the delivery system.
Mr. Srivastava, I'm sorry, I would just like a rejoinder on that. My question specifically is that has there been an improvement in this short period? Let me put it 3 years. Has there been an improvement in the treatment of law towards the public at large, or has there been a lack of improvement as compared to before? Not when it comes to any kind of legal action against the state, but between members of the public.
I don't think that there is any such a situation which is there where the members of the people are not receiving treatment. There are various problems in the society, but those problems are systemic. I mean, those problems, they are not individual specific.
Thank you, Mr. Srivastava. Mr. Rajneesh Jindal, please unmute yourself and ask your question live.
Thank you, sir. Thank you very much, sir, for this enlightening session. My question is actually with respect to the law and practice itself. Because right now, what actually as a teacher I'm witnessing, like we teachers are not allowed to enroll in the bar council, but the advocates can come and they can teach. So when as a teacher, we find that, see, ultimately for a student, it is necessary that they should acquire practical as well as theoretical knowledge. So once a teacher is to be allowed to enter into this profession, then ultimately it will lead to more fruitful outcome. Because recently Gujarat High Court, they have clearly mentioned that the teachers can enroll into the bar council and even they can go for the practice as well. But why this hindrance is there for the teachers only?
Sorry, can you repeat about the Gujarat High Court? What did they say?
Sir, yes, yeah, Gujarat High Court, basically they have clearly mentioned that nowadays the teacher can be enrolled themselves as an advocate. So Gujarat High Court has passed this order, sir, recently in the last week itself.
So this is basically a policy matter. I mean, there can be views both in favor and against it. But personally speaking, I mean, I do not find any problem, I mean, conceptually, in teachers being enrolled as lawyers. But you know, I mean, as far as I know, in US Supreme Courts, even in the US Supreme Court, the law professors are allowed to practice. They can argue cases. And when they appear, I mean, of course, they would be of greatest value and assistance to the court with their learning, with their knowledge of the law. But in the contemporary circumstances which are prevailing in this country, I mean, we cannot import the idea in an abstract manner in every situation, in every country. What I understand is that being a law teacher is a full-time job, which may not be there in other countries, in other jurisdictions like US. Here is a full-time job. Under the mandate of law, you require a full-time teacher. At the same time, a lawyer is not allowed to be engaged in any other profession as such, other legal profession. So to the extent it is synchronized and it does not compromise or conflict with the duties and functions of the teacher and the lawyer and the lawyer and the teacher. Speaking for myself, I do not see a problem, and I would be happy to, if that can be made possible in some manner.
Sir, actually, I have a point to made over here because see, ultimately the students, when they can go for the internship, because obviously the law course is itself is a full-time course for 5 or 3 years. So when they can opt for the internship kind of thing, then why not teachers can be considered for that kind of duration?
You're right, but then the internship is a part of the curriculum itself. That's a part of the course. And they engage in the internship during the period when they are off from the campus, from the university. So doing internship does not conflict with their study curriculum. That is what my understanding is.
Okay, thank you, sir. Thank you very much, sir.
Thank you, Mr. Srivastava. Mr. Abhishek Kaushik, please unmute yourself and ask a question.
Thank you very much for the erudite session, sir. It is always a pleasure either to watch you argue in courtroom, Supreme Court, or hear you here. It's always a pleasure and a learning experience. So thank you, Mayuri, for convincing Ravindra sir to come and speak to us. And thank you, sir, for coming and giving us such a erudite lecture on such a vast topic, as you rightly mentioned.
I'm over with it.
Sir, my question is actually on the nature of practice as lawyers, as we do, representing big corporations, especially builders. You and I am asking this question to you because this actually comes from experience. When I'm representing a party, I may have a very sound case on law, but sometimes conscience, karma, etc., that starts to operate in the mind, even for a lawyer who is to only represent one party and not decide. So we don't have the luxury of deciding. So we can put across, but at times the dilemma, the trolley's dilemma, as they call it, is always operating in our mind. When we see the legal point, though, is in favor of a particular client, but the conscience speaks otherwise. What should your advice be to youngsters, people like us, who are faced with this situation? Because you come from a rich experience and you yourself have represented so numerous numbers of corporation builders, in which you know that there are people who may be suffering, but legal point has to be put across, and you have always maintained that dignity. How do you do that, sir? And what is your advice for us? Thank you, sir.
That's a dilemma, or that's a problem which is very common. In fact, I have suffered the same innumerable times. And I have also my very fixed notion. Sometimes there has been huge conflict in my mind between my professional duty and my own sense of conscience, as you have rightly flagged it. It happens very often. And particularly it happens when somebody is very sensible and tries to do his job very honestly. But remember, once you have chosen to be a lawyer and become a law practitioner, and you have accepted somebody's brief, and in order to provide him access to justice, then you have only to look into the brief and try to do as much as or as best as you can. You know, your conscience is not necessarily the judicial conscience. The perceptions or the thinking, your individual, must not be imposed on your duty or on the interests of the client. In initial period of practice, this is a very common thing which was happening, and I also suffered it. Many times there was huge crisis. In some, particularly in matters of sexual offenses, I had very strong views. But then gradually, ultimately, your job is to look after the interests of within the structure of the law, not by adopting any unfair means. So your duty primarily as a lawyer is to provide him justice or provide assistance in the course of justice within the framework of the law, so that he gets the best treatment of the procedure of law in a fair manner, in an impartial manner, in the best possible law, and nothing is missed out in the process of the delivery of justice which may harm his interests. So that is how the only way you can resolve the dilemma.
Thank you, Mr. Srivastava. Mr. Saurish, please unmute yourself and ask your question.
Thank you so much, Akshay. Ravindra sir, good afternoon. Thank you so much for a wonderful lecture.
Good afternoon.
It was very enlightening for me coming from in-house practice to learn about so many important aspects which we tend to miss out while we are inside closed doors. So thank you so much for that. I wanted to ask you an interesting question and a topic which you also raised. There was a law student whom I met recently at a social function. He asked me that when you hear you are a lawyer, you've been in the profession for such a long time, when you hear so many allegations made in the media against judges, does it not make your blood boil? Because that is something, a scar against your own profession. I gave him an explanation about how things have progressed, etc. But then you made a very interesting point, sir, that the structure of our judiciary, the condition of our lower courts are very bad, and there needs to be independent funding to ensure that these things are brought in place. So, what would you think would be a mechanism to generate that independent funding so that we can get the judiciary in the same space as others? And I was wondering, as one of the thoughts which came to my mind when I was talking to that student was, is there a way we can, like most government institutions where we visit, we have to pay a small fee to enter, like a library or so. So, I mean, one of the suggestions which I thought could be that if somebody wants to enter into court after COVID times, then they need to pay a minimum fee, say 5 rupees, 2 rupees, etc. And that could be an independent fund for the courts to ensure that they improve the court infrastructure itself. Any other thoughts on this, sir? Thank you so much.
Yes, I mean, that's a very complex matter, how to generate. I mean, yes, of course, I have talked about creation of an independent commission to look after the needs of the judiciary and provide funding. But the funding ultimately will have to come from the public coffers. I mean, there can be some contribution. Ultimately, when you pay the court fees supposedly required for the, it should go for the court infrastructure, for the administration of justice. I mean, these days, I think when you, in Wakalatnama, you put the stamp duty, I mean, or some welfare fund is there. So these are the sources, I mean, but they are not enough. There is very, very small sources of revenue. But basically, the funding must come from the funds, from the consolidated funds or whichever fund is there. There must be a due and fair allocation of funds for the judiciary. Now, right now, what happens is there is no law, there is nothing which governs it. It is all dependent upon the executive's wish and their pleasure. They decide while making the budget as to how much fund will be allocated for the judiciary. Now, at times it may be objective, sometimes it may be totally whimsical. So there has to be a body which will objectively assess not only the requirement, but at the same time, the limitations of the fund resources and make recommendations which should be absolutely binding on the authorities, on the government and the Ministry of Finance to release the funds. That's what is the idea in my mind. That is, so create that structure by law, which can be enforceable and where some agency or the authority is made accountable. So that is not happening. As far as your other question with regard to the allegations which are surfacing these days in the public domain, that's a very unfortunate situation and very, very, very unfortunate. And after 40 years of practice and at this end of my career, it makes me very sad because we never saw that when we joined the profession. The courts and the judges were very highly respected. And the system will survive only when there is a dignity and there is a respect. What is the ultimate authority of the court? The ultimate authority of the court, which is often mistaken, does not flow from the power of punishment under the Contempt of Courts Act. We have seen what happens when the contempt powers are exercised. And very recently we have seen that. But the ultimate authority comes from the respect of the system and the respect of the individual judges, which is paramount. So therefore, not only it is necessary for the judges and all those who are in the system and who work the system to conduct themselves in a manner where there will be least opportunity or occasion for generating any sort of situation which may invite slur. But at the same time, the others have also to behave in a very responsible and sensible manner, because what is paramount is the trust and confidence on the system. That's the only basis on which the system runs and can run. And that is unfortunately deepening. There is a period of crisis of confidence, and everyone must take upon itself the responsibility of preventing it.
Thank you so much, sir. This is very enlightening. And I'll pass on your thoughts to the law student. I'm really grateful.
Thank you very much.
Thank you so much, Mr. Srivastava. Ms. Mayuri, could you please take up the question that you have? Participants who
running out
are
of time.
waiting for their turn. Yeah, I have 3 people on the waiting line, ma'am, but I will let you go forward and ask your questions, and then we'll seek permission from sir if he wants to take those 3 questions towards the end. Over to you, Ms. Mayuri, ma'am.
Sir, we have this question from Madam Meera Matthews. She is asking that it is often predicted by legal professionals that a rampant application of artificial intelligence in future will change the practice of law, not merely positively, but negatively too. So her question is that, keeping in mind the Indian scenario, so what do you, how do you see what will be the effect if artificial intelligence is used in the legal profession?
Thank you for this question. I think it's a very important question. And there has been much talk about the use of technology and use of artificial intelligence in the law practice or profession at both ends. The work and the functioning of the judges, courts, and also the lawyers. It is much talked about. I'm really not an expert, but as a man with some ideas and what I can reasonably perceive is that artificial intelligence, when it is used in a very sensible manner, can be of great use. What are the areas where this artificial intelligence will really work is a matter of detailed study. But I do realize that it can enhance the efficiency. It can enhance the system also, the efficacy of the system. Has to be a hybrid model. You cannot envisage a situation where the artificial intelligence will totally be sought to substitute the individual mind and the wisdom, particularly in the area of the administration of justice. Justice is basically, I don't ever imagine, I cannot, barring a few areas where it is more a systematic approach or a mechanical approach, like computation of the taxation liability or so on, something like that, where it is a matter of statistics and data and accounting based on the acceptable technological inputs and data. In other areas, the administration of justice is a human function, let's say, justice delivery. Now, what would be perception of a fact, which is established fact or which is a proven fact, will depend upon the conspectus of the circumstances, which will have to have a judicial bearing of mind. You know, many times, far from the high law principles or the logic, what we require is logic. What we require is common sense. And common sense, is the virtue of only the human being, the mind of the human being. So if it is possible, and let the experts put their mind into it, to develop a system which is a hybrid system, where the artificial intelligence works in aid and in conjunction with the man and the manpower of the system, I think some good results can be produced. Ultimately, we are in the era of the technology. Technology has some positive, some good aspects, and we must make use of it. For example, this COVID times has seen that how best the technology can be used whatever little access of justice we have today is only because of the technology. Otherwise, all the courts would have remained locked and would have been getting only dust. So artificial intelligence must be seriously thought about, but it's a matter of a study in the context of the legal profession by experts, how to make use of it. Thank you.
So if you permit us, would you like to take more questions? I know we are running out of time.
Yes, of course. I do realize that I have taken, in fact, I should have compressed my speech itself. But some other time, madam, I'm willing to come again in your forum, not in this formal fashion, but I'll be most happy to engage myself in a sort of interaction, most informal interaction with the students. Anytime I can, when the circumstances permit, I can visit your campus also. I'll be too happy to meet your learned members of the faculty, and I'm sure each one of them are great teachers. So,
Mr. Srivastava, may I request for just one more question, sir? Just one more question. This individual has been in the waiting line for very long, so just one last question.
okay.
Mr. Divekant, please unmute yourself and ask your question live.
Good evening, sir. This is Devikant Lahoti. Good evening, Professor Ravindra. Hello, Mayuri. Sir, I'm a huge fan of yours, and I have the pleasure of engaging you in various matters in Supreme Court. And I also have a long association with Symbiosis Law School and especially Professor Ravindra. I have been waiting since last half an hour to pose one simple question. And I can see that the amount of interest which have been generated by your talk today, sir, it is beyond imagination, sir. And I humbly congratulate you, sir. So my question is very simple. So you have been an Advocate General for the state of Chhattisgarh, where you have been interacting and reflecting your views of the legislature to the judiciary and assisting judiciary in whatever needs they want from the legislature and from the executive. Now, sir, in this COVID times, we have seen technological changes and judiciary adapting these technological changes in a catalyst form overnight. Now, sir, the question is, what do you think that state should do? Because state has the finance in its hand. What state should do or center should do to facilitate e-courts and access to e-courts to majority of the litigants and litigators who do not have that technological access, whether that would amount to non-access to justice. That's number one point. And second thing is, in order to avoid that non-access to justice because of technological challenges, what state government or central government should do to reduce that inconvenience to the litigants?
Thank you, Devikant, and I'm indeed grateful to you for this question. It's very, very searching question, in fact. And you know, and many would know that what a great admirer I am of yours as lawyer, as a gentleman also, and how much I love you. I'm very proud of you indeed. Now, your question is not simple. Your question has many nuances. But let me tell you that access of justice at all times is non-negotiable. It is absolutely important. There are no ways that you can prevent access of justice by any class of people. Now, when there is a need to access justice, and these days, which is possible only through the use of technology, which we are seeing, unfortunately, this privilege of using technology is limited, is available to a very, very limited segment of the class, very minuscule, maybe very minor. We know of the situations even in the high courts. We cannot give example of Delhi and Bombay and Bangalore everywhere.
True.
A very developed metropolitan I think you only mentioned sometime that what a huge difference the daily subordinate court judges are willing to work on technology through video conferencing, where in the neighboring, within the NCR, the others are not, or are finding it difficult. So there are 2 or 3 things which are necessary, and the state has to play the predominant role. One is that of the creation of infrastructure, undoubtedly, and there is a huge which is lacking. We are too short of infrastructure. That is first thing. The second is the facility. I mean, that we have most of in the subordinate courts, what we see from our experience and what I hear from our colleagues, that most of the time the lawyers are trying to struggle with the use of the technology through the mobiles only. They don't have laptop or the desktops from which they can have access. Even the technology is available. The internets are not available everywhere. They're not functioning in a very proper, robust manner. Now, more than that is creation of a mindset of adaptability. There has to be awareness, the spread of awareness that use of the technology is now the only way out. There is still many dogmas, many apprehensions about it. Supposing sometimes if the witnesses are to be cross-examined through the technology, there are several questions raised. Some of them may be genuine, some of them may be well-founded, or some of maybe must over-exaggeration of the problem. Likewise, examination of accused arguments. So that kind of spread of awareness has to be generated at all levels. We must realize the foremost, and the state has to play a very major role, a very proactive role. But what unfortunately happens is, then the state does not get alive to these kind of challenges and do the needful at the time. So there are, if individual systems cannot be provided to the people who cannot afford it, all the lawyers who are practicing across, and particularly in the subordinate judiciary, may not be in a position to afford an expensive system. But at least centers can be created by the state by spending some money and acknowledging the priority of the task, from where the facilities are available and from where the lawyers can access the courts. Likewise, there can be video conferencing halls created in the courts if individual systems are not provided. So it is doable, it is possible, but there is a lack of political will. I must say that the government needs to be sensitized.
Thank you, sir. Sir, I think the last comment, I think the government has to work upon the last comment that you make.
Yes.
Thank you, Mr. Srivastava. To all the attendees who have been in the waiting line, I'm really sorry we can't take any more questions. Over to you, Ms. Mayuri.
Thank you, sir. So thank you very much for such an enlightening session. And I need not say this, that it has generated so much interest, not just among the learners, but also among the professionals. And with this, I request Dr. Ravindra, sir, to kindly take the baton and please conclude the webinar with a vote of thanks.
Thank you, ma'am. Before I start investing the 5 minutes which I have with me, let me begin with the thank you, because it was not a lecture. Rather, it is an experience which one has earned and is sharing with the ones who are participating. People at different intervals who have joined, in a sense, they have come into life. They may have experience of that part of life, but what you have lived since inception till date, that you try to communicate to us. I remember there are 2 statements of my 2 teachers which I remember, and I fondly call them as Gurujis, so I'll prefer the term Guruji over the teacher. I remember my first day of jurisprudence class which was happening, and Madam Badwade was teaching us, Dr. Badwade at ILS Law College. So she was just posing a question to all of us. What do you mean by law? And what this LAW stands for? So people were giving all that, what is called as the subjective definition of law, legislatum and etc. But nobody was able to convey what ma'am really wanted us to explain. So she said, LAW stands for logically applied wisdom. So LA and W. So she said, what law is, what law was, what law will be, that keeps on changing. But what remains is that you are born with the wisdom, how you develop the logic and how you put it forward. Then I remember another professor when I was doing my second post-graduation in law from Cardiff Law School, Mr. Howard Johnson. And he said his introductory class and the first two statements, I welcome the ones who are here to learn and I do not welcome the academic tourist. So the moment he used the term academic tourist, we all were like, what does he mean? He said means the ones who have come here just to see the beauty of United Kingdom and they would just like to move around. They need not come to my class, but who really have come. So there are two things which the two statements communicate to us. This is my understanding, that it is good to have objectivity, but you cannot miss on subjectivity. So you say that when it comes to law and the practice of law, you need to have both the subjective understanding as well as the objective fulfillment of that understanding. And if one misses either of the ones, they never will reach there. I remember one of the debate where I was participating and the title was so apt. It was in Marathi, but I'll just title it in Hindi. Dharma atal hai, dharma hi atal hai. Like, people understand dharma atal hai because, we had made this, one of the statement that when I'm born in a family, I did not choose my religion, I got the religion. But when I start living the life, I choose the religion and I live that religion. So what you are born with, that you have, that you get. Well, of course, that you can change, but what you become, that is your work, that is your understanding, that is your learning and what you take. So, in the words of Acharya Chanakya, means as I have been reading, so I remember he says dharma is constant, and dharma does not mean religion, because he contests it with karma, dharma, karma, and then rather prakriyas. So he said, Chala Lakshumesh Chala, Parnas Chale, Jivit Mandire, Chala Chale Cha Sansare, Dharma Eko Hi Nischala. In English, it can be said as money, soul, life, body, all things go with time. Only dharma remains. And that's what you say. Law will always remain. Law is not to fulfill anyone's ambition. Law is there to get what is called as the fulfilling justice to everyone. So for that, what we require is the professionals who are driven. There was somebody saying, a question was asked by one of the colleague, Mr. Jindal, that professors, that the teachers of law cannot practice, but practitioners can come and teach. So it is not to oppose the practitioners, but it is one way of communicating, because unfortunately, legal profession is said to be a profession, but it is not treated to be, because one section is treated, other section is not treated, because still we believe in qualifications than the professional experience. And if, as you rightfully said, sir, if you go abroad, especially in United States of America or in Europe, they strongly believe in the professional understanding acumen than the qualification one has received or earned. So that is one point which we need to really focus. You also focus on the aspect that we need to practice our knowledge. So I was looking for the right Sanskrit shlok, which is given by Acharya. So he also has on Gyan ka abhyas bhi kare. So he say, Anabhyase visham shastram jirne bhojanam visham. Daridrasya visham gosti vruddhastha taruni visham. Means he says base food doesn't help the body in the problem of indigestion and works as poison. So is the absence of sustained exercise of skills and subjects also does the same thing to a professional. So we have to practice. So what we believe in, we also have to practice. And you related that with one of the questions very well, that it saddens us when we hear out that such an allegation is made, but at the same time, we don't allow that to get in, because now we are the torch bearers, we have to take it ahead. Allegations will come, allegations will go, but what goes on is the dharma, because it is constant and we have to practice what it is. So thank you very much, sir. In short, what you communicated to us, I understood by my own understanding, and I thought that that is the best taking. And I always like to relate it with a story, and I just could not stop it, because the story is about King Vikramaditya. I remember, and this has been told to us in school so many times, but we still understand. And if you remember, because King Vikramaditya was the king of Ujjain, and he was famous for his justice. And this story has nothing to do with his time when he was living, but later on. And this is about a shepherd boy who was grazing cattle and who was sitting on a mountain on the heap. They call it as a mound. And he was just playing with his friends, and he was delivering some judgments. They were playing with each other, but what he delivered. And later on, people got to know, and they started going to that boy. So when he was sitting on that mound and what he was delivering, and that also reached to the king of Ujjain, how that boy could deliver it. And then they figure out that there was throne of justice on which Vikramaditya used to sit. So end of the day, it is the understanding. Then the king of Ujjain, he dig it. Everybody knows that story. He dig it, and he wanted to have that throne so that he can sit on it and he can deliver judgment. So as a result, he got it and he tried to sit. There were angels which were attached to, marble angels which were attached to the throne. So one of the angels just came out the moment that king tried to sit on it, and that angel said, "Stop. Do you think that you are worthy to sit on the judgment seat of Vikramaditya? Is your heart as innocent as that of a shepherd boy?" So it just informs us that when you are sitting, you're occupying the seat, you become what you are there to deliver, not what you are, and then you deliver. And that also you communicated. I'm just trying to relate it with the story of Vikramaditya. Thank you very much for bringing that childhood story understanding to my mind. And it was a wonderful session. It was, people may say it has nothing to do with law, because law has to do with us. So we require law. So it was about understanding, which goes into lawmaking. So thank you very much, sir, for this wonderful session. And I would like to thank Ms. Mayuri for introducing every now and then to wonderful individuals like Sri Ravindra Srivastava ji. And thank you very much, Mr. Akshay. Like, you always have been so supportive, and you always are there for every initiative which we take. And I would like to thank all participants, all the attendees for staying so long. So thank you very much, everyone.
Thank you very much. Thank you. Wish you all best, very best.
Thank you, sir.
Thank you so much, Professor Ravindra, Professor Mr. Ravindra Srivastava, and Ms. Mayuri Raghuvanshi.
Thank
Taking
you.
permission to end the webinar, Professor Ravindra.
Yes, we can, Mr. Akshay.